Item number 30.
30.
Lordship. It will come after 2 weeks, Lordship. I'll come personally.
30. Item 30, at the request of counsel for the respondents,
Lord.
the stands deferred to be listed after 2 weeks.
Lordship.
Please, Lordship, I beg to mention for listing, my lord. Any date next
What matter?
writ petition, my lord.
Subject matter,
Subject matter regarding minimum pay scale, my lord.
minimum pay scale. All right. 30
30
April.
most of
Yeah.
May I please move? My lord, with the consent of the other side, my lord, from item number 25 to 29, my lord.
Yes.
My lord, this matter may come after 1 week, my lord, any date yet. My lord, problem is that I don't have the, my lord, the affidavits, accept the writ petitions. So if your lordship permits, my lord, can I get it? Because I'm not getting the details of the affidavit. I've asked the other side also. That
You have
they are
taken
also,
consent from the other side.
yes, okay. I have the consent, my lord. I have taken consent.
I think I can see Mr. Goswami sitting there. I don't
Sir
know
is
if
there,
he's
but
hearing.
the junior PP
You are in
is
this
not.
matters, Mr. Goswami? All right. 25 to 29.
Yes.
Matter stands deferred at the request made by Mr. J. Paying, learned counsel appearing for the Home Department. NRC. List after 2 weeks.
Any date, yes. My learned junior friend is there, my lord. As your lordship deems. I have no objection. Any date.
After 2 weeks.
Obliged.
First, I beg to mention for listing two cases, one for withdrawal, another for admission, lordship. From one lordship matter, other matter which is to be listed for admission related to release of the pensionary non.
30. Bring it on 30.
Lordship. And withdrawal matter may be on Monday.
Tomorrow also if you want.
Lordship,
Monday. All right.
All right.
May it please, your lordship. Lordship, item number 32 of supplementary list, lordship. In fact, this writ petition came up yesterday. Item number 33. It has been wrongly mentioned connected to item number 33. It is, in fact, it was in the cause list of yesterday. So, lordship.
Wrongly listed.
Lordship. And your lordship has.
No, which is wrongly listed? 32. Okay.
And in the writ petition, your lordship has directed to list after 2 weeks. So let this IA also be listed along with the.
Item 32 be listed along with WPC 428 after 2 weeks.
Only thing, may I pray for a fixing a date, lordship?
Fixed date 9th May.
And much obliged.
Lordship, I'm praying for listing of a matter, your lordship. In this case, actually, notice was issued on 4th of April, my lord. But the order of a different case is reflected in our case. So, your lordship, we are not able to take steps. So, for that correction, I'm praying for listing of it.
Have you done 30? 30?
30.
When do you want it?
Monday, maybe.
28, all right.
Most obliged.
May I please, your lordship, I beg to mention for listing one case, lordship, ISC Bill 1252, /25, lordship. Lordship, in this matter, when I filed this petition, they are harassing me. Plus, again, after filing this on, I have filed on.
What is the subject matter?
Subject matter, lordship, it is against the adverse order, lordship. And it is against the passing of the adverse order. Adverse remarks. Lordship, it may come on Monday, lordship.
Not Monday.
Monday, lordship.
Not Monday. Either you
Tomorrow.
30th or 2nd.
30th. Lordship on 30th.
30th.
Master.
Lordship, beg to mention for listing for hotel matter tomorrow.
May I please, your lordship? Lordship, I beg to mention item number 1. I am praying for an adjournment for the day.
Wait. Let the matter be called up.
Okay.
I beg for listing, lordship.
Listing what?
National pay of fixing. National fixing of pay.
National fixing of pay. 9th May.
Obliged.
Yes.
Lordship, in this matter, the allegation was that the results were not declared and some candidates were telephonically informed. In fact, Lordship, perhaps the petitioner is not well informed. The results were published in the Times of India, Kolkata, Guwahati edition, 7th March. He was not successful. That is why he's
Lordship, maybe example that the S Council Arbora had serious injury last week. Serious injury last week. Council Arbora. I am mentioning on his behalf.
All right, we'll have it on 30, 30.
Gosh.
List on 30. At the request made by the council for Mr. Arbora, council for that he suffered injuries last week. Is unable to attend court. Mr. RKT Chaudhary, learned TSDI, appears for the response. List 30.
May please. In this matter, as per last order, Lordship, order dated 9/4/25, kindly see it. 9/4.
Dada. Sir, the decision has been taken.
What was the direction?
Lordship will find that melod in page,
Yet 16.
page melod 16,
16 is the operative.
last para. The DP has been concluded. Now, my lord, what I could find is, my lord, the last part of the order, which says thereafter respondent one shall consider the petitioner's representation for voluntary retirement and shall take a decision thereon within a period of 1 month. Now, that decision is to be taken. This has been passed on, my lord, 20th of April. So that shortly, my lord, that order will be passed, my lord, regarding the representation for VRF. DP concluded. So, Lordship will proceed after 3
Let
weeks,
them
my lord.
file affidavit, Lordship, because there's two direction, Lordship. One
Yes.
partly
You see, do you have a copy of this order?
Yes, yes.
You see the last paragraph, serial number 2.
One, two, three.
Unauthorized leave till the date VRS will be effective. They are taking steps to consider your VRS.
Because their direction, two direction is there, Lordship.
Right.
Let them comply, Lordship.
Yeah.
Fully
Lordship is not
comply,
closing it, my
because
lord. Let it
until
be
and
after 2
unless
weeks.
they comply the second direction, Lordship.
Third learned counsel for the parties, Mr. P. Gugoi, learned counsel appearing for the respondents. Has placed before the court copy of the order, speaking order dated 2004/2025, whereby the disciplinary proceedings initiated against the petitioner has been completed. He further submits that the decision, the respondents in respect of the representation filed with the petitioner for voluntary retirement will also be decided within a short period of time. So, how much time do you require?
Let it be after 3 weeks, madam. Because of the Panchayat election, some of the
therefore
officers are
submits that the
deputed
matter
there.
be listed after 3 weeks.
Madam.
Para counsel for the petitioner submits that the directions contained in the order dated so and so, past in WPP so and so, are twofold. Firstly, to complete the disciplinary proceeding within a period of 3 months from the date of receipt of a certified copy of the order, and further to consider the petitioner's representation for voluntary retirement. and to take a decision thereon within a further period of 1 month. Stop. He therefore submits that the conclusion of the disciplinary proceeding is only one part of the directions contained in the order dated so and so passed by the High Court. He submits that the matter be listed again. Matter may be listed. The matter be adjourned as prayed for and be listed again on a fixed date. A list again on 9th of February, 9th of May.
No, my lord, I think it will be
You
2
want
weeks
it
only.
after
Yes, well, on 19th, 19th of May.
19th, all right, 19 May.
Obvious.
I pay for the respondent number 2. He was newly implemented. We have received the instruction, but as it appears, it's not up to date. They have taken a recourse to do something about the presentation filed by the petitioner, but it's not clear if they have taken that decision or not. And I'm appearing for the first time to do that. Lordship will grant us
You
some
want
time.
some time,
Yes,
Mr. Esogia for the petitioner, Mr. D. Lega for respondent number 2
true, Lord.
submits that he has entered appearance today for 3 weeks' time to complete the instructions. Let the matter be reviewed again after 3 weeks.
My lord, that may be fixed.
3 weeks. The respondents may file their affidavit in the meantime. At least on 19th.
My
May.
my
My lord, additionally, P. Naik will appear in this matter, my lord. He is in another court. After some time, my lord.
The department has yet to file their counter.
My lord, yesterday I got the paragraph comments. I can file it by Monday, my lord. Let it be on 30th.
Mr.
30th.
J. Patwari for the petitioner, Mr. P. Gogoi, an additional lady for the state, submits that his instructions are complete. You'd like to bring it on record by way of an affidavit.
By Monday I will
Let
file it.
the matter be listed again on 7th
Seven.
May.
Interim order has to be.
Interim order passed earlier will continue.
Obvious. Also, in the case, we need 2 weeks time, Lordship.
Huh?
2 weeks time, Lordship.
lordship, as per the last order,
It
lordship,
was listed before Bihu, Lordship, immediately there was case on Lord.
the lordship prayer for interim order to be considered, lordship.
What is your grievance?
Events is that lordship, she retired. After retirement, 3 FIR has been lost against the petitioner, lordship. So in one FIR, charges has been filed, lordship. In other 2 cases, not charges, neither final report has been filed, lordship. So as per the Assam pension rules, lordship, as per rule 22, lordship, she is at least at this stage, lordship, entitled for provisional pension, lordship. People, lordship, kindly come to Assam pension rules, rule number 20.
Is there any proceeding against her?
Lordship, that instruction I have not received, Lordship. Lordship, this matter was listed on 8/4, Lordship. Thereafter, Lordship, I'm sorry, but Lordship, Lordship, give me 2 weeks time, I will file my affidavit, Lordship.
Hmm.
2 weeks time, Lordship, I will file my affidavit.
You file it after 6 weeks, but tell us whether any disciplinary proceedings are pending or not.
That is, Lordship.
We are having it again on 2nd May.
Second,
Second,
Matter be deferred to be listed on 2nd May,
Obvious.
on which date the council for the irrigation department
Lordship.
will apprise the court whether there is any departmental proceeding pending against the petitioner.
Lordship.
Prayer for interim will be reconsidered on the next date fixed.
Obvious.
Mr. Chaudhary appears, A.T. Chaudhary for the petitioner, Mr. Upadhyay for irrigation, Mr. Mehdi for accountant general, M.S. U. Sharma for pension. Yes.
After some time later.
Hmm?
After some time later.
You are supposed to give the judgment.
Lordship, just shortly please the judgment. Lordship, I'll just inform you.
This is a serious matter. We can't
Lord,
go on joining like this.
I'll just inform you.
No, not after some time. Have it next week sometime. He'll come up next week.
Or just 5 minutes, your Lordship, I'll inform him. Lord.
You inform him, we don't know. If it is, we are not calling up again. All the other councils, have you submitted your written arguments? What about the union? You for the union? Gimana? Bagi kira? Gimana kau nak dia naik kita tu? Yes.
I think 36 melody is not similar melody. Last occasion I have pointed to melody. Suppose they were supposed to apply the court, whether it is similar or not.
All right, item
36 melody.
36 be delinked from the series at the request of counsel for the petitioner.
Lordship, item 42.
36 and 42.
My lord.
Right, delinked.
But there is an
The
interim order
series.
there. There is an interim order there.
We don't know. It is delinked. It is delinked. You say it is separate.
Yes, my
Then-
interim order.
Their interim order was passed in the series.
Separately passed my lord.
Whatever is there is there. We continue.
My lord.
You urge your case when the matter is called up, you should have urged your case to say that this is different, so it should be.
My lord. Sorry. My lord.
Right. Next week. Huh?
Well, here I am looking for a respondent, madam. Or in fact, madam, pleadings has already been completed. But one aspect of the matter is that petitioner has challenged the Annex 6, that is page 93. There is a 309 rule, madam. So my humble prayer for since
No, sorry. What has been challenged here?
the rule
Where?
at page
Where
93.
is the prayer?
Prayer, madam, at page
Page 35, 36 your lord.
36.
36.
You are
Recruitment rule
looking for setting
2012 has been
aside,
changed.
setting aside of the rules.
Rule.
That's to be before division bench. Heard. This writ petition is directed. This writ petition is filed assailing the queries of Ministry of Road Transport and Highways, Border Roads Development Board, General Reserve Engineering Force, within bracket Border Road Organization, Junior Engineer, within bracket Electrical and Mechanical, bracket close, Group, capital P, Forced Recruitment Rules 2012. So in that view of the matter, registry is to place the matter before appropriate division bench. The registry is to place the matter before the Honorable Chief Justice on the administrative side for being placed before the appropriate division bench.
In item 9, my lord, I am going to file the rejoinder affidavit today. And I'll serve a copy. The matter may be taken.
Yes.
Lordship,
Mr. S. Nath for the petitioner submits that he will file the rejoinder affidavit during the course of the day. And the prayer is not objected to by Ms. B. Sharma. Matter be listed again Some interim order is
Yes, Lordship, interim order is there.
there. On 13, 13 May.
13.
Can I just take one liberty, my lord? In that case, I have got a judgment, my lord. Whether I should hand over or on next week when the matter is listed, I will do that.
You place it next week.
Okay.
Yes.
Item 10, Lordship. The matter is about the arrears salary. The petitioner is entitled for arrears salary and the PW department admitted that he is entitled and they have forwarded the file to the finance department, but it is pending in the finance department subject to the approval. It is yet to be approved. So I have filed a petition for implement of the Secretary of Finance Department. So
IA
is not listed to the Lordship.
Then?
And I am praying for adjournment and date.
Counsel for the petitioner submits that an IA has been filed praying for implement of
Secretary of the Finance Department. Dr. Vasu.
Finance Department. The said IA, however, is not listed. Have you filed it or you're going
Yes,
to
I
file
have
it?
filed. Lord.
Your file?
Yes.
Is it numbered?
No, it is not yet numbered.
It's submitted that the IA has been filed but has not yet been numbered. The registry to verify and list the IA along with the present petition after 1 week.
Can I pray,
or
pray
it is for the respondents.
Can I pray for a date?
No. You don't even know the status of your IA. It has to be not numbered means
I
subject to defects.
I have a filing number.
Registry will do the needful next week,
Okay.
after 1 week.
Okay.
Huh? What do?
Typing items 4 and 5.
Please. Coming for admission hearing.
Pleadings are complete.
Pleading for
In
I have filed my affidavit, but I don't know whether they have filed any reply or not, because I have not
in 5461, perhaps no affidavit is there.
This case is completely different. I for they are the regularization of developed by the administrative department. But the issue is not any regularization of that. And I accordingly I got it done.
You are appearing in 5382, 5328.
We are appearing in 5.
In
5.
5328.
5328. Yes, there is an affidavit and not a reply.
We have filed out. Yeah.
Yes.
May I please have? This is Milord, a case relating to what they call Milord work charge employee in the PWD department. And the basic question is whether they are entitled to pension.
Their work charge.
They are supposed to be work charge employees. If we go by the traditional meaning of work charge, they are not, but that is how we are labeled. And initially, that is how appointments took place. So they have worked for several, two decades at least. We have given the charge of the people who work. And they were not given the scale even in the first appointment order itself, and their service records were initiated and compiled. They were given increments, annual increments. They got the benefits of the rises, and they continued from the date of appointment till they were superannuated without any break. And the question now is, Milord, whether they have given all other dues except they said that you are not entitled to pension. So that's the short point. This issue, Milord, there are some decisions which have come from 2019 onward relating to this kind of an employee who is said to be a work charge employee. And the Supreme Court has given the verdict that they are entitled to pension if they have worked all through without a break. So there is no reason why they should be deprived of their pension because their service was taken by the government. And there is no break in the service. And the traditional concept of a work charge employee is, below, that his salary and other payable dues are charged to the work he is doing, as your lordship know. Therefore, the work ends and he also goes out. That's the idea. But if it happens that you get an appointment letter, I'll show your lordship the appointment letter, with a basic scale, and you are continued for the rest of your working period till you reach the age of superannuation, and you are working within the department in different works, that concept vanishes because it is one after other, whatever he is allotted, he is doing. So in a situation of that type, whether the person concerned is entitled to, he is not, although the level is work charge, he is not in effect a level work charge employee. The appointment itself, if your lordships have a look now, at page 24. Page 24, Milord, if you have to.
24.
Yes.
Yes.
I've given a sample of our appointment. Okay. 24 to 47. Page 24 to 47 are the appointment letters, Milord. I am just placing one of them. In the interest of public services, Sri Pramod Kakoti, so petitioner number 1, is hereby appointed as Worksas section assistant in the scale of pay of the scale is given, Milord. This is in 93. Plus other allowances as admissible under rule in Bhopal Road subdivision. The appointment is purely temporary and may be terminated at any time without notice. All the others are also in a similar string. And they continued, Milord, and the retirement is If your lordships have a look, Milord, at page 48. Here's petitioner number 3, Pulin Bihari Uda. Workshire Section Assistant of PWD Guwahati East Road Subdivision under this division is hereby released from government services with effect from 31/10/19 on attaining the age of superannuation. So this is absolutely without any break. And is now copy to 4, the person concerned, with the endorsement that for information and necessary action, he is requested to consult with the respective establishment assistant for onward process to release the benefit. Office order, book of records. So that is here an office service record which is maintained right from the day one, and all the increments that are given annually, all this is recorded as a regular employee in the government. So the other dues, everything is given except they say that you are not entitled to pension. And that's the short issue before your lordship. We have given the chart, Miller, that page 10.
Page 10.
Yes. Paragraph 5. That being duly qualified to hold the post of grade 3 and grade 4, the petitioners, as has been stated herein above, were appointed as Workshire sectional assistant under Public Works Department on various dates. It will be relevant to state herein that the recruitment of the petitioners was as per the then prevailing procedure, and in fact there was no other method of recruitment which was followed by the PWD at the relevant point of time when the petitioners were appointed. Pursuant to their engagement, the petitioners have duly discharged the duties allotted to them from time to time without any break and without any blemish, and to the satisfaction of all concerned, till the date of their superannuation. For the sake of brevity and for easy reference, the dates of appointment and dates of superannuation of the petitioners are given hereunder in a tabular format. So we have given Milord the 12 petitioners before your lordship. The different dates are given, Milord. For example, the first one, the appointment date is 30/11/93, superannuation 39/18, so about 25 years. And this, Milord, please, 93 only one, 96 one, and rest 1994. Para 6. The petitioners, after their engagement, have been continuing to serve under the respondent authorities in order to fulfill the object sought to be achieved by the state respondent. And at times, the petitioners were transferred from one place to another within the zone. The petitioner, from the date of their engagement till their superannuation, had been rendering their service with utmost dedication and sincerity to the entire satisfaction of the authorities concerned. Till date, the competent authority in the Public Works Department has not raised any objection on the eligibility and credibility of the petitioners that they are failing to perform their duties satisfactorily. It will be relevant to mention herein that the respondents opened service role of the petitioners to record various deposits and increments. The petitioners paid the liberty of this to produce the same. And then continued to serve the respondents till their respective dates of superannuation. All this is then given Miller. And they got all other thing at paragraph 8, they say, as far as pension was concerned, the petitioners were told that they were not entitled to pension. Then they filed a representation, which your lordship will find at page 49. Page 48, I think I have already said. Yes. Page 48 is the release from the government service on attaining the age of superannuation. And then this page 49 is our representation. And at page 51, Miller, paragraph 2, we have set out that we have continuously been in service.
They were given regular scale of pay.
Yes, Miller, the appointment letter your lordship has seen, and we have said at page 51, Miller, if your lordship just have a look at paragraph 2, that during the course of our service, we have discharged the different assignments given to us from time to time. Our services were without any break in service, and in fact, we were given scale of pay, service book, service roll were opened in our names, and we were also provided with increments at various stages. In fact, we are granted the benefits as was given to any regular employee. Moreover, our salaries and allowances were part of the budget proposal, which was duly sanctioned by the government. In this context, it will not be out of place to state herein our salary included components such as grade pay, DNS allowance, house rest allowance, medical allowance, and the same are identical to the salary and components of the persons who have been regularized or any other such regular government servant in the department. As such, for all purposes, we have been treated as regular workers by the government, and we have discharged the various duties allotted to us till we reach the age of superannuation. Our service records will clearly show that the government treated us as regular employees for all purposes, and we were employed in substantive capacities as against budgeted for. And it continues at page 52. We say that we are given everything like a regular employee and treated like that. And this was never replied to Miller. Then we had to move your lordship. And two notifications, Miller, office memorandum. If your lordship just have a look at page 55.
Yes.
Page 55, Miller.
5-5.
Yes. Annexure D, office memorandum dated 12/9/96. The pensionary benefit to the state government pensioners, family pension holders. In the Government of Assam circular issued under Office Memorandum dated 10/8/63, Finance Department, a temporary government employee who retires after rendering temporary service of not less than 20 years under the government without being confirmed in any post is to be allowed the pensionary benefits as available to a retiring confirmed government employee, either on attaining the age of superannuation or on his being declared to be permanently incapacitated for further government service by the appropriate medical authority. Said OM came into effect with effect from September 82. The Governor of Assam is now pleased to clarify that all temporary government employees who have retired from the service under Government of Assam fulfilling the criteria of not less than 20 years of continuous service will be eligible for pension from 1st September 82 onwards. This is, however, subject to the condition that they satisfy all conditions other than the conditions of permanency against permanent post under the Government of Assam for usual pensioner benefit under Assam Services Pension Rule 69. This benefit not be admissible to any retirees who retire from service with retirement benefits under CPF. And we have stated that we have not got the CPF. At page 13, we have said. So this is been not very clear that a temporary employee also, having served for 20 years, is entitled to get the pension on superannuation. And that condition of permanency and permanent post was waived. And we have already said, the place in page 9 and page 51 without any break. Huh? And then we'll have a look at page 57 also, which is a similar notification on 6/9/2003, making the earlier notification absolutely clear. In continuation of this department dated 12/9/96, which your Lordship has seen at page 55, it is reiterated that the state OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. The focus is on 20 years of continuous service. After rendering 20 years of service, if the government servant is superannuated or incapacitated or dead, is not moot point. Any confusion in this regard is against the spirit of the OM referred to above. It is therefore clarified that pensionary benefit as contemplated in the above OM shall be admissible to a government servant who died after rendering 20 years of continuous service. Other terms and conditions of eligibility of pension will remain as is. So this is absolutely clear, two notifications, Miller, saying that if you have worked for 20 years, even as a temporary employee, you are entitled to pay. That is the situation, Miller. The state's affidavit, Miller, PWD, affidavit in opposition of R2. Essentially, the essential points have not been controverted. They admitted paragraph 4 at page 52 that they were engaged as work charge section assistants under the PWD Guwahati Road Division and continued their service as work charge section assistants till their superintendent. So that is service period is admitted. Then Miller, the reason given in paragraph 5 is that as regards to the statements made in paragraph 4 of the writ petition, the deponent begs to deny the averments made by the petitioner and humbly begs to submit that the petitioners were engaged as work charge section assistants after 1493, and as such, their services were not regular. They retired from service as work charge personnel, and therefore they do not satisfy the conditions necessary for getting pensionary benefits under the Assam Pension Rule 69. So the fact that we have served is not disputed, and what are these two do not satisfy the conditions, that is not spelled out, but it is a bare denial. Well, as regards the statements made in paragraph 5, the deponent, paragraph 6 I am reading, begs to submit that all the petitioners were engaged as workers under the Article Guwahati Road Division after 1493. Government of Assam never took any decision to regularize the services of any workers personnel engaged subsequent to 31/3/93. Since the petitioners were engaged after 1493, their services could not be regularized as per policy of government. The annexure D and E, Miller, page 55 and 57, which you also have seen, Miller, are both dated 12/9/96 and 6/9/2003. So it contradicts the environment, contradicts the notification. And para 12, the rest I am keeping out because there is nothing. They have referred to these two memorandums below at page 64, para 10. That as regards to the statements made in para 10 of the writ petition, the deponent begs to deny the averments made by the petitioner and humbly begs to submit that the office memorandums dated 12/9/96 and 6/9/26 mentioned in the paragraph by the petitioners are applicable to the temporary government employees working as temporary posts but without confirmation of service, as they are not appointed against a permanent or substantive post. Further, the office memorandum dated 12/9/96 appropriately made it clear that other than the condition of permanency against permanent posts under the government of Assam, they have to satisfy all the conditions for usual pensioner benefit under Assam rules. Accordingly, state office memorandums are not applicable to the workers employed personnel, even though they retire from their service after completing more than 20 years. So, the notification are explained in this manner without any rational reason as to why they are not applicable to these temporary employees who were not confirmed. Because the purport of the two notifications which your doctors have already seen, the second notification Miller clarified and emphasized that the basic point is the length of service. If they have continued for 20 years, they are entitled to the pension. which is a very reasonable thing in itself.
Yes.
And paragraph 13, page 65, it's very difficult to understand why they are saying that the notifications do not apply. Further, deponent begs to say that the statutory provisions debar grant of payments in favor of the petitioners as they are work charge employee and not a permanent employee or temporary employee. A work charge employee becomes entitled to pension only when his service is regularized. Please note this. and we serve for 20 years without a break. And they take their service and pay all the dues otherwise, and they are now becoming niggardly as far as pension is concerned. So basically, there has been no contradiction or dispute on the basic facts. We have nonetheless submitted a reply where we have reiterated the thing. In paragraph 5, we have said that the memorandums are applicable and they have to do it. And at page 70 below, paragraph 6.
70?
70 below
70.
70, continuation of paragraph 6. In fact, at the top below, in fact, it is the categorical and specific case of the petitioner in the writ petition that as they were duly qualified to hold the post of grade 3 and 4, they were appointed as a work charge sectional assistant under the PWD department, and their appointments were as per the then prevailing procedure, and at that point of time there was no other method of recruitment which has been followed. It may also be relevant to state herein that there is no denial of the said fact by the respondents in the paragraph in the reply. Moreover, as has been stated here above, on account of non-regularization of their service, the petitioners are seeking pension on the strength of the aforesaid office memorandum dated 12/9/96 and 6/9/93, which are still holding the post as on date. So, the only ground is that they have not regularized. Government takes the service, treats them for all practical purposes as regular. They do not regularize. That itself is faulty. And now they take advantage of that default on their part to say that since they have not been regularized, you are not entitled to pension. Which their notifications say that even if you are temporary, you are entitled to it.
You claim to be covered by the notification.
Yes, below. There is no dispute that I am a temporary government servant, regularly appointed by them, giving us all other benefits except this pension. And we are treated like a regular employee. So this is the pleading part, Now, the only ground is that we have not regularized, therefore you are not entitled to pension.
If you are regularized, you become a regular employee.
Yes, my lord. But if, my lord, the facts indicate that they have been treated like a regular employee, the non-regularization itself is of no consequence. We are appointed on a scale, we cross the efficiency bar, we are given increment, we continue without blemish, continuously, without a break, for all the service period. And we squarely come within the notifications they are saying even in 96 and which is repeated in 2003 to make it very clear that the period is the crucial point, not regularization or non-regularization. Their own notifications are binding on them. That apart, Milord, this has been now clearly, Milord, said in a judgment of the Supreme Court, which is, Milord, 2019 in SCC 516.
Prem Singh.
Prem Singh, Lordship, no. 3 years bench, Milord. Because in that case also, there were two categories, Milord. One set of employees were regularized, the other set was not regularized. And the court has said that non-regularization itself will not bar from getting their pensions. Indeed. This is a very
But in Prem Singh, he was subsequently regularized.
Milord, there is one group who are regularized. There was one group who are not regularized. If your lordship will kindly take this, I'll just point out that. Milord, kindly turn to page para 30 at page 540. If your lordship kindly turn to paragraph 30 at page 540. After setting out the submissions made at paragraph 29.
Paragraph
29, the submissions are recorded. Just read that also, Mullah. 29. The submission has been urged on behalf of the state of UP to differentiate the case between work charge employees and regular employees on the ground that due procedure is not followed for appointment of work charge employees. They do not have that much work pressure. They are unequal and cannot be treated equally. Work charge employees form a totally different class. Their work is materially and qualitatively different. There cannot be any clubbing of the services of the work charge employees with the regular service and vice versa. If a work charge employee is treated as in regular service, it will dilute the basic concept of giving incentive and reward. to a permanent and responsible regular employee. These are the submissions. 30. There are 30. We are not impressed by the aforesaid submissions. The appointment of the work charge employee in question had been made on monthly salary, and they were required to cross the efficiency bar also. The same situation in our case, How their services are qualitatively different from regular employees? No material indicating qualitative difference has been pointed out, except making bold statements. Same position in our case. The appointment was not made for a particular project, which is the basic concept of the work charge employee. That's what is important. Rather, the very concept of work charge employment has been misused by offering the employment on exploitative terms for the work which is regular and perennial in nature. Exploitative, that's the expression used. The work charged employees had been subjected to transfer from one place to another like regular employees. As I have read out from our pleading, we are also transferred at times. Like regular, as apparent from the documents placed on record. In RN that and so, the appellants were allowed to cross the efficiency bar after 8 years of continuous service. Our service records indicate that even during the period of work charge services, Nayan, the appellant, was appointed as a work charge employee as case mop-up with effect from 15/9/78. Payment used to be made monthly, which is our case also, but the appointment was made in the pay scale of 200 to 320, whatever was the prevailing scale we were given. Initially, he was appointed in the year 78 on a fixed monthly salary of 205 per month. Our case is better, my lord, that we are appointed on a scale right from the day one. They were allowed to cross efficiency bar also, as the benefit of pay scale was granted to them during the period they served as work charge employees. They served for 3 or 4 decades, and later on, services have been regularized time to time by different orders. However, the services of some of the appellants in few petitions and appeals have not been regularized. So there are two categories, as I was saying, So some of them were regularized, some were not regularized. Even though they had served for several decades and ultimately reached the age of superannuation, just like our case, second group. In the aforesaid facts and circumstances, it was unfair on the part of the state government and its officials to take work from the employees on the work charge basis. They ought to have resorted to an appointment on regular basis. The taking of work on the work charge basis for long amounts to adopting the exploitative divide. This is what has happened so far as we are concerned. The taking of work on the work charge basis for long amounts, adopting amounts to adopting exploitative divide. Later on, though their services have been regularized, however, the period spent by them in the work charge establishment has not been counted towards the qualifying service. Thus, they have not only been deprived of their due emoluments during the period they served on less salary in work charge establishment, but have also been deprived of counting of the period for pensionary benefits, as if no services had been rendered by them. The state has been benefited by the services rendered by them in the heydays of their life on less salary in work charge establishment. In view of the note appended to Rule 3.8, there is no provision. There is a provision to count service spent on work charge, contingencies, or non-pensionable services in case a person has rendered such service in a given between period of two temporary appointments in the pensionable establishment or has rendered such service in the interregnum two periods of temporary and permanent employment. The work charge service can be counted as qualifying service for pension in the aforesaid exigencies. So there was a rule which provided this, my lord, namely between two temporary appointments that can be done. But this has been now worked out and read down to say that you can't make that distinction. The question arises, 33, whether the imposition of rider that such services to be counted has to be rendered in between two spells of temporary or temporary and permanent service is legal and proper. We are really not concerned with this because we don't have a rule of that nature, and our notifications clearly say that if you have served for 20 years, you are entitled to pension. We find that once regulation had been made on vacant post, though the employee had not served prior to that on temporary basis, considering the nature of appointment, though it was not a regular appointment, it was made on a monthly salary, and thereafter in the pay scale of work charge establishment, the efficiency bar was permitted to be crossed. In our case, right from the day one, as your lordship has seen, it was a scale and we have crossed all that. It would be highly discriminatory and irrational because of the rider contained in Rule 3.8 of the 1961 rules, not to count such service, particularly when it can be counted, in case such service is sandwiched between two temporary or in between temporary and permanent service. So this has been said that it will be discriminatory. There is no rhyme or reason not to count the service of work charge period in case it has been rendered before regularization. In our opinion, an impermissible classification has been made under Rule 3.8. It would be highly unjust, impermissible, and irrational to deprive such employees benefit of the qualifying service. Service of work charge period remains the same for all employees. Once it is to be counted for one class, it has to be counted for all to prevent discrimination. That's the essence. The classification cannot be done on an irrational basis, and when respondents are themselves counting periods spent in such service, it would be highly discriminatory not to count the service on the basis of flimsy classification. The writer put on that work charge service should have preceded by temporary capacity is discriminatory and irrational and creates an impermissible classification. That rule was therefore read down. We don't have a problem of that sort by a rule. In fact, our notifications are fairer than that, and it takes into account the entire service if they have done. 34. As it would be unjust, illegal, and impermissible to make aforesaid classification, to make Rule 3.8 valid and non-discriminatory, we have to read down the provisions of Rule 3.8 and hold that services rendered even prior to regularization in the capacity of work charge employees, contingency paid fund employees, or non-pensionable establishments shall also be counted towards the qualifying service, even if such service is not preceded by temporary or regular appointment in a pensionable establishment. So this case virtually states, below, that the entire period will be taken into account as a qualifying period of service for the purpose of pension. In view of the note appended to Rule 3.8, which we have read down, the provision contained in Regulation 370 of the Civil Service Regulation has to be struck down, as also the instructions contained in Para 669 of the Financial Handbook. We are not concerned with those because similar things are not in our rules. 36. There are some employees, this is the category we belong. There are some of the employees who have not been regularized in spite of having rendered services for 30, 40 years or more years, whereas they have been superannuated. As I was saying, there are two categories, one regularized, one non. And this is the second category, non-regularized, like us. as they have worked in the workshop establishment not against any particular project, their services ought to have been regularized under the government instructions and even as per the decision of this court in Umadevi. This court in the said decision has laid down that in case services have been rendered for more than 10 years without cover of the court's order as one-time measure, the services be regularized of such employees. In the facts of the case, those employees who have worked for 10 years or more should have been regularized. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct that their services be treated as regular ones. However, it is made clear they shall not be entitled to claiming any dues of difference in wages had they been continued in service regularly before attaining the age of superannuation. So that wage part was not given, but it said that you have to take that into account, even though they were not regularized for the purpose of pension. They shall be entitled to receive the pension as if they have retired from the regular establishment, and the services rendered by them right from the day they entered the workshop establishment shall be counted as qualifying service for the purpose of pension. Nothing can be more clear than this. In view of the reading down of Rule 38 of the UP, Rule 61, we hold that the services rendered in the work charge establishment shall be treated as qualifying service under the aforesaid rule for grant of pension. The arrears of pension shall be confined to 3 years only before the date of the order. So that is another stipulation. Let the admissible benefit be paid accordingly within 3 months. Resultantly, the appeals filed by the employees are allowed and filed by the state are. So this is a clear case of 3 judges of the Supreme Court, Milord, saying that mere levels of work, in substance, if you have worked, got the scale, service records were maintained, efficiency bar was crossed, then your status is of a regular worker. And it is a default on your part that you have not regularized. So that should not deprive them from getting the pension. So in our case, Milord, the only plea that is taken is that they were not regularized. Who has prevented the state from regularizing in spite of their 2 notifications, Milord? After all, Milord, you are taking the service. And pension is not a bounty, as your lordship have held. The first case of 71, constitutional judgment, Milord. Deokira. And that is repeated in Nakara, as your lordship know. It's not a bounty. It's a service rendered and taken. It is only fair that you take care of his needs after he goes out and help him in living a reasonably decent life without problems. It is never adequate, but this is a big help, at the old age. So this is a clearest judgment on the point, holding very clearly that merely a level of workshop will not end the quest for pension. If the facts indicate that you have taken their service, maybe they are temporary, you have not regularized, even then the pension will be payable and the period will be taken into account in qualifying as a qualifying period of time. Here our is 20 years, qualifying period. 20 years. as your lordship has seen the notification. So we have completed that period. And therefore, in my humble and respectful submission, Miller, the case is squarely covered by this judgment, and the state should have followed their own notification and granted the required pension. These are very difficult times, my lord, and all through, my lord, your lordship has seen they were not, in fact, given what they should have been given. But that apart, now, my lord, to take, not to take that period on the ground that it is, we have not regularized. What more do you want? You have given, you have taken the service, you have given the scale of pay, you have transferred them when you wanted, you have, it is not attached to a particular work, you have continued from work to work.
Transferred also.
Yes, we have mentioned that. Hmm? They are transferred from zone to zone. So it is all, they are treated like a...
It has all the characteristics of a permanent
or a regular employee. Even the skills are, appointment letter itself has given a scale. And then the counts service record. 81, petitioner number, is still on the number. But you will just give me a moment. Okay. Carson complete. Carson. Page 10. Mantu Ramki. 94 no? Human बसे बोलते कोई no? Just for your lordship, the number given petitioner. Yes, sir. Well, just for a quick brave leave to produce the service roll below. This is here we are giving petitioners 5, 6, and 5, 6, 8, 12. Just for your lordship. Petitioner 5, 6, 8, and 12. These are called mirror service role for grade 4 government service. Then all the details are mentioned below, and then below. Then all the details are, there is a format under the government. And all the payments made, increment sanctioned, increment granted. Everything is mentioned, like a regular employee. Increments are given from time to time. So all this just indicates below that the virtually it is a we crave leave, that's why I'm just placing this. In our petition, we have said that all these are maintained and we have they have given everything and this is recorded. All this is there. It's just like a regular employee of grade 4. Prem Singh, in my humble submission, is a tribal judgment and it really covers the present case. But there are subsequent cases on that. I don't want to refer right now because they relate to different rules of different state governments which are dealt with. But one or two judgments I will just give a lordship here. Give this. This is Milord Sripal versus Nagar Nigam Ghaziabad. It is 31-125. It is Sripal. It is entry at 9 देखूँ 9 देखूँ dated 31st March. Oh no, January 25. Sripal and versus Nagar Nigam Ghaziabad. Judgment of Vikram Nath. Same thing, Miller, about exploitative. Para 14 at page. Paragraph 14. Paragraph 14, Miller. Page 16. Pages at the bottom.
What were the facts? What were the facts here in the matter?
The facts are also, Miller. This really arose out of a industrial dispute, Miller, and awards were given, and out of that, Miller, the matter has come from in the reference and the awards of the labor code. The submissions are at page 6, paragraph 5. I need not trouble your lordship with all that, but I just wanted to show only one part of the thing, because the employer described them as a casual employee also, and they were working paragraph 14, Miller, at page 15. The respondent employer places reliance on Uma Devi to contend that daily wage or temporary employees cannot claim permanent absorption in the absence of statutory rules providing such absorption. However, as frequently reiterated, Uma Devi itself distinguishes between appointments that are illegal and those that are irregular, the latter being eligible for regularization if they meet certain conditions. More importantly, Uma Devi cannot serve as a shield to justify exploitative engagements persisting for years without the employer undertaking legitimate recruitment. This is only for that purpose I was citing this thing. But your lordship has already noted about the exploitative thing in the earlier case I have cited. And there is one other observation which I thought was relevant for our purpose. That is at page 20, end of paragraph 15, and just before paragraph 15 starts at that page, page 20. Page is at the bottom. Denial of basic rights and benefits. Temporary employees are often denied fundamental benefits such as pension, provident fund, health insurance, and paid leave even when their tenure spans decades. The lack of social security subjects them and their families to undue hardship, especially in case of illness, retirement, unforeseen circumstances. That is the only thing I wanted to show. The selection is given to regularize them in 15. In Himud Bhagra. There is one more melody, only the interpretation part. This is without the citation is, I think, 2024 Supreme Court SC 115. There's only one paragraph which I wanted to show how the court has dealt with Miller. Paragraph 17 at page 4, Miller. About interpretation of a pension scheme, Miller. Paragraph 17. It is well settled that pension scheme floated by the state government form a part of delegated beneficial legislation and ought to be interpreted widely, subject to such interpretation not running contrary to express provisions of the pension rules. Furthermore, it will be relevant to underscore that state government is a model employer and ought to uphold principles of fairness and charity. Only for that purpose I would say. I'll have a to
Yes.
Short judgment, Lord.
Hmm.
And this is to details. State of Gujarat versus Talsibhai Dhanjibhai Patel of 18 to 22.
Here you'll have to refer to the High Court then. What happened?
This is Supreme Court, Lord.
I know. Yes, upheld the High Court judgment.
Yes.
In I think one or two paragraphs.
Yes, it's just one paragraph. Only thing. Short telling paragraph, Lord. Sometimes very short one also. It is unfortunate that the state continued to take the services of the respondent as an ad hoc for 30 years and thereafter now to contend that the services rendered by the respondents are ad hoc. He is not entitled to pension or pensionary benefit. The state cannot be permitted to take the benefit of its own wrong. To take the services continuously for 30 years and thereafter to contend that the employee who has rendered 30 years continuous service shall not be eligible for pension is nothing but unreasonable. As a welfare state, the state as such ought not to have taken such a stand. In the present case, the High Court has not committed any error in directing the state to pay pensionary benefits to the respondents who has retired after rendering more than 30 years of service. Ultimately, law is not always logic. It is human experience, Miller. You are a government, you have all the resources, and you take their service and then try to take it very technical plea. We have not regularized. You should have regularized. 30 years, you are taking all your characteristics and dealings have given him the character of a regular employee. There is no difference between this employee and a regular employee. Then another thing about Sandeep Mehta football. Uh, 2024-0 Supreme Court SC 684. I can't make out what kind of a citation is this. Possibly my friend will tell us. This is also a similar line, Miller.
What is the citation?
That is 2024-0 Supreme Court Supreme SC 684. And the citation is this is of August 24. Para 33, I am only just indicating that page 13. Para 33. In the present case, the totality of circumstances indicate that despite their formal classification as temporary employees, the appellant's employment bears substantial hallmarks of regular government service. Denial of pensionary benefits solely on the basis of their temporary status without due consideration of these factors appears to be an oversimplification of their employment relationship with the government. This approach runs the risk of creating a class of employees who, despite serving government for decades in a manner indistinguishable from regular employees, are deprived of the benefits and protection typically accorded to government service. And this fits into our case. The Nakara citation, your lordship know I can only give the citation 83-1 SCC 305.
For pension.
Pension, Miller, not a bounty. The first case is 1971 1409.
71 ST.
ST 1409. I think it is at 1419. This is a constitution bench judgment. That is the first case where they say that it's not a bounty. Meta copy detail. Para 29 below.
Para 29
of this judgment below. ARS 71 Supreme Court 1409. According to petitioner, right to receive pension is a property, and if respondent by an executive order to so wrongfully withheld his pension, the order affects his fundamental rights under 19(1)(f) and 31(1) of the Constitution. Respondents, as we have already said, do not dispute the right of the petitioners to get pension, but for order passed on so and so, there is only a ball environment in the counter. There's no question of fundamental rights. This is long, well established figure. I think also as an year, we have given you both of you. So, to sum up, the facts clearly indicate, that the employees were appointed, given scale, utilized their service for long periods, and they have fulfilled the requirements of the two notifications. And the only plea taken in the government affidavit is non-regularization, which, in my humble submission, is covered by that paragraph of Old Mr. Judgment Miller, 2019, where it says that group of employees who are not regularized. So that has been dealt with and rejected. So that alone cannot deprive these people of the pension, which is otherwise due. And all the facts indicate, virtually that they are treated as a regular employee. There is no distinction between them. And non-regularization by the government is a default on their part, and they can't be allowed to take advantage of that to deprive the petitioners of pension. And the notifications clearly indicate, Millard, that the purport of which is merely the length of service, namely the 20 years, if they have served, they acquire the right to get the pension. And these people have done that. These are my respective.
And you also say you are covered by those circulars. What do you think?
Yes, yes, absolutely. Their own circular. And the only plea is that they have not regularized it. But the characteristics associated with this group clearly show that for all practical purposes, they were really treated as a regular employee. So this plea of non-regularization itself is not valid. In any case, Miller, that will not deprive the petitioner of the dues, and that 2019 judgment, that portion relating to the non-regularized employees who were given the benefit is absolutely squarely covered our present case. That group was not regularized. That Mishra's case, that case below, the one group was not regularized, and that has been dealt with, as your lordship has seen, by the 2019 judgment. Prem Singh,
Prem Singh.
Prem Singh clearly dealt with that group. One group was regularized, the other group was not regularized. So non-regularized also got the same benefit. By doing that default thing, you don't benefit yourself at our cost. T23. Yeah, like it is. I would have done it.
Any judgment of our High Court in this regard?
Milord, High Court was dealing with, Milord, the earlier batch of cases, that Upendas and others, when these judgments were not there. That is the whole difference. And when the relief was given, it was on the basis of that Kehar Singh's case, minimum the scale is given. And they say that henceforward do not appoint workshop. But they continued to appoint. So the way they have appointed, your lordship has seen, with a scale start with.
You are saying that when that
All these cases, the whole scenario had changed after this 2019, in my most humble submission. Because we have all along been saying that these are all casual employees, work charge employees, what right they have. But work charge concept itself has been belied by the fact. Work charge is only attached to a particular work, and the expenses of these workers are part of that value of that work. And their service ends with the completion of the work. And that has been explained by Justice Mr. Judgment, because the three judgment framework. So we fit into that completely. And their actions clearly indicate that we have been treated like a regular employee. There is no difference. What is the difference between a regular employee and us?
one of your submitters that when that file reconsidered?
Because I am not getting involved into that because this is a judgment which has dealt with squarely with the issue we are confronted with. And this judgment is followed. So that is a turning point, watershed point. Keher's judgment, below that long judgment, ultimately regularization, what is regularization, how it will be done, what is non-regularization, that decided ultimately, Milord, who were found to be regularized or could be regularized, what was the relief granted? The minimum of the same. That was the that was the final decision, and we followed. All courts in India, high courts have followed that. Our judgments also reflect that at that stage, even for PWD, that you can be given the basic minimum of the regular scale. But those facts were, at least from the judgments, I don't find. Therefore, we have stated all these facts to make it clear how they were dealt with right from the day of appointment, and why you can't classify them as pork chop. The same thing which Prem Singh said, that they don't conform to that concept of a pork chop employee. You have not treated them as that. They continued without break for decades, and you have taken their service, and you have given all other benefits except pension. And there is no rational reason. The only reason I find from the affidavit is non-regularizing. Who has prevented you from regularizing? You should have. For decades onwards, you will not regularize and then come to the court and say that, okay, they are not regularized, don't give them the pension. That is absolutely discriminatory and unreasonable. And the notification is very clear that, okay, that is, although there is no set of rules, notifies absolutely clearly that the soul of the thing, as they say, is the period of service. If you have served for the 20 years period, very good. You will get the pension. Because they have taken their service without any blemish. And we have pointed out, we have made the environment and craved to produce the service. All of them have the same thing. We have just given the few of them. There is therefore a wind of change, Milord, which has taken place.
That's the majesty and beauty of law, that it keeps on changing.
Yes. ever changing and ever evolving. That's the beauty of law.
Dynamic concept.
Dynamic.
But
there was a time when one would not have. There are decisions where it was said that it is only casual. What can we do? But it has gone a step further and saw the substance of the employment. and the way they were treated. All this is relevant, my lord.
But our High Court had already passed an order with respect to Prem Singh.
Yeah.
First part,
Okay.
those who did not have the qualifying service. Single bench of our High Court had long passed it, long back. I think Opiram Raju.
Or Rajvangshi.
Huh? No.
Counting of the non-regularized part.
Opiram.
Obiram Raj. Thereafter also after that Pandita Ray judgment came. Now that principle has also been overruled by the Supreme. No part of the ad hoc service or casual service can be taken into consideration for the purpose of qualifying. That is the latest that is the latest judgment doctrine after 2019. But that is not the issue in this case.
That is not the issue because they had a different rule.
All right, you conclude your argument.
This is my basic submission. After my learned friend finishes, I will reply. Yes, sir. Oh, no.
You rely on the argument.
This is that Kobiram melody. Yeah.
No, we don't want it.
No, your lordship can have it.
Recollected.
No, you are rightly recollected. We also have it. I didn't want to multiply. Because that period, whether entire period will be taken or a part of the period will be taken, that is again a controversial period thing. But so far we are concerned because the 20-year period is fully satisfied. That's why I am not going into the subsequent cases, which really was on the point as to whether the entire period will be taken or not, and how much of it will be taken for qualifying as a qualifying service period to get paid. That controversy in our case is not there. That's why I didn't like to unnecessarily trouble your lordship with that. Because those were different rules and therefore the interpretation, whether Prem Singh's view was taken or not, there is a slight difference. So we are not concerned because our rule is very, notification is, and the rule is very clear that it is 20 years service. So they have fulfilled that. That is all. I mean,
Doctor, so far as the facts are concerned, Doctor, I have nothing much to say. But first, I would say, Lordship, all these appointments, Lordship, all the appointments of the petitioner were subsequent to 31/3/1993. 31/3/1993. All these appointments are subsequent to 31/3/1993. And state government, Lordship, never frame any policy for regularizing any master law works as employee engaged subsequent to 31/3/1993.
Yes.
So their services were never considered for regularization. Thereafter, Lordship, in the year 2012, in the month of June, Lordship, Government of Assam Finance Department issued one notification laying down that henceforth there will be no more regularization of master roll and works as employee, and there shall be no more creation of supernumerary roll. Lordship, that notification was challenged in several writ petitions, and ultimately a learned single judge of this honorable court set aside that notification of 2012. And all those and that judgment was challenged by the state government in the case of WA 45 of 2014, that is State of Assam and Upender, and in 836. And the division bench overruled the judgment passed by the learned single judge. So the decision of the state government
not to regularize any master roll or work charge employee subsequent to 2012 remain valid. And also the decision not to create any supernumerary post. In the judgment of Umar B. Dotted, the division bench said that no judgment can be passed for regularization of the services of the petitioner. All those petitioners were engaged prior to 31/3/1993.
These petitioners were
engaged subsequent to 31/3/1993, and the state government never framed any policy for regularization of the master roll and work charge employees were engaged subsequent to 31/3/1993.
yes. Yes.
So that is the basic case. So my basic of my submission is that there is no such instruction or no such policy of the government for regularization of the master roll and work charge employees who were engaged subsequent to 31/3/1993.
Yes.
Now coming to the notification straight law, look at page 57.
Yes.
If Lordship reads this notification, Lordship, this is the clarification part on. In continuation of the department's OM number so and so dated 12/9/1996, it is reiterated that the said OM clearly lays down that a government servant rendering 20 years of continuous service without being confirmed shall be eligible for pensionary benefits. The focus is on 20 years of continuous service. This is only the clarification. After rendering 20 years of service, if the government servant, Lordship will record these words, Lordship, government servant, is superannuated or incapacitated or dead is not root point. Any confusion in this regard is against the spirit of the OM report to above. It is therefore clarified that pensionary benefits as contemplated in the OM shall be admissible to a government servant who died after rendering 20 years of continuous service. Other terms and conditions of the eligibility of pension shall remain same as usual. So this notification clarification applies only to the government employee, not to those who is not a government servant, and all those petitioners whose services were not regularized cannot declare themselves as a government servant. Now, if Lordship comes to page 55, Lord.
Yes.
Page 55, this is the original notification of 12 September 1996. In the government of Assam, circular issued under office memorandum number so and so dated 10/8/16/1963, Finance AFP Department, a temporary government employee who retires after rendering temporary service of not less than 20 years under the government of Assam, without being confirmed in any post is to be allowed the pensionary benefits as available to a retiring confirmed government employee, either on attaining the age of superannuation or on his being declared to be permanently incapacitated for being government service by the appropriate medical authority. The said OM came into force with effect from 1st of September 1982. The Governor Assam is now pleased to clarify that all temporary government employees who have retired from the service under the Governor of Assam fulfilling the criteria. So this is the type copy, Lordship. Some mistakes are there. fulfilling the criteria of not less than 20 years of continuous service will be eligible for pension from 1st of September 1982 onward. This is, however, subject to condition that they satisfy all conditions other than the conditions of permanency against permanent post. So this is important, Lord. Permanent against a permanent post under the government of Assam for usual pensioner benefit under the Assam Services Pension Rule of 1969. These benefits not be admissible to any retiree who retire from service with retirement benefits under CPF route. So two things are there, Lordship. One is temporary service without confirmation. So basic, Lordship, for confirmation is holding a substantive post. If you are not holding a substantive post, your service cannot be confirmed. And in case of confirmed employees, Lordship, the qualifying period for pension is 10 years. But in case of temporary employees, temporary government employees, whose service cannot be confirmed because they are not holding a substantive post, in their case, Lordship, the period of qualifying is 20 years. So that is the distinction between this notification and a regular government employee holding a substantive post.
How many years have they completed, petitioner?
They have completed 20 years.
Petitioners.
Yes. Probably their appointments are
More
also
than 20 years.
Yeah.
The chart you have given me. More than 20. All of
So what is the distinction is that, Lordship? Lordship, this notification applies only to temporary government employees, and without being regularization of their service, they cannot claim to be a government employee. Now, Lordship, let me give one example, Lordship, in whose case this notification applies.
Yes.
Lordship, that notification, that is another notification, Lordship, that I have to place on another date, Lordship, because today I am not holding that copy. Lordship, in 2005, Lordship, Government of Assam took a decision to regularize master role and works as employees who were engaged prior to 31/3/1993. And that point of time, Lordship, around 30,000 persons number of persons were regularized, works as master role, casual, etc. Lordship, in their case, Lordship, posts were created against each person, Lordship, whose services were regularized. And it was made clear that all these posts will get abolished once the person holding that post relinquishes that post in whatever manner, he dies, he retires, whatever manner, that post will get abolished. So that is a temporary post under the government. A post, temporary government post. A person regularized in 2005, those 30,000 persons regularized against a temporary government post, and those posts automatically got abolished once he relinquished that post by way of retirement or he expires, whatever manner. In their case, this notification of 20 years happened. So all those persons, Lordship, whose services were regularized in 2005, they have to fulfill the criteria of 20 years to be eligible for pension. So that is the distinction between this temporary government employee and the writ petitioner. So this notification is not applicable in case of the petitioner whose services were never regularized, and this notification applies to those regularized master role and workers employees whose services were regularized either in the year 1995 or in the year 2005. Lordship, this notification of 2005, Lordship, based on a subsequent date.
So, but if they were regularized, where's the question of not being confirmed enough?
Because these posts were temporary posts. These posts were not substantive posts. That is why I am repeating, Lordship. This post gets abolished once.
What is the distinction between being regularized and
regularized against a temporary post? That is the distinction. Temporary government servant Regular government servants.
The effect of regularization.
Lordship, regular government servants are those who are holding a substantive post. Substantive post means person comes, person goes, post remains. In case of temporary post, Lordship, person comes, post may go in the meantime, Lordship. That is a personal kind of post, the personal type of post, Lordship.
That is all right, but what is the meaning of the term regularization? What is the effect of the regularization?
Lordship, which was earlier irregular, that has been regular.
What benefits do you get?
He gets everything, he even gets pension. But in their case, Lordship, this notification of...
Let me rephrase it. Has he become a government servant?
Yes. After regularization, he became a government servant.
If he becomes a government servant, then where is the question of confirmation? Not
Lordship,
confirmed.
that is the difference, because they were regularized against a temporary post. But other employees were...
The confirmation is a term to be used when you are in a temporary appointment. Ad hoc. Temporary.
No. Confirmation applies in case of substantive post. When the post is substantive and your appointment is against a substantive post, your services may be confirmed.
That means your initial appointment is temporary.
On probation, Lord. But
On
against a substantive post. Regular appointments are against a regular substantive post. So that is why their services can be confirmed. But as regularized master worker services were regularized against a temporary post, their services cannot be confirmed. And that is why this particular notification of 2003 applies to those whose services cannot be confirmed. So this is a notification. For that also, Lordship, you have to fulfill the criteria of being a government servant.
What is the government servant? Who is the government servant?
After regularization, he becomes a government servant.
But you just said for regularization, you have to fulfill a criteria of being a government servant.
No, I'm not saying that. Lordship, appointment can be against a temporary post or against a substantive post. But in this case, they were regularized against a temporary post. As they were regularized against
the criteria for being regularized.
Lordship, in 2005, Lordship, criteria was taken that they were all engaged prior to 31/3/1993. That was the criteria taken. And they worked more than 10 years. That 1993 was there. And that criteria has also been fixed by the Omalibi in paragraph 53. Three criteria were fixed. So those are the criteria. So at this stage, Lordship, I am only limited to this notification of 2003, in whose case this notification applies. My submission is that this notification...
2003 follows 96.
Yes, original was in 1996 and clarification was in the year 2003.
All right.
Now, Lordship, if I place the notification of 2005 for regularization of those 30,000 employees, Lordship, it will be more clear, Lordship, who is a temporary Lordship. That notification, Lordship, I will place on a subsequent date, Lordship, because today I was not apprehending that car will appear. So that is why I was ready with other judgments, but not to respond to those arguments. So far as Prem Singh is concerned, Lordship, only 2-3 paragraphs, Lordship, I would like to read, Lordship, and I would like to submit why this judgment is not applicable in the present case. If Lordship comes to page 522, Lordship will first have to see what was the issue in that judgment.
522.
522, Lordship may kindly see first paragraph. The question involved in the present matter is whether Rule 3A of the UP Retirement Benefit Rules 1961, in short, the 1961 rules, and Regulation 370 of the Civil Services Regulations of Uttar Pradesh should be struck down, having regard to the fact that this court has upheld the decision regarding perimeter provision enacted in the state of Punjab, which excluded computation of the period of works or services from qualifying service for pension. This court had affirmed the decision of the High Court of the state of Punjab and Haryana rendered in Kecherson versus state of Punjab. So the Supreme Court was considering a particular provision of a particular act. Paragraph 3. The facts are being narrated from Prem Singh versus State of UP 2009, arising out of SLP number so and so. The appellant was appointed as a welder in the year 1965 in a workers establishment. He was transferred from one place to another, and thereafter ultimately the selection committee recommended for regularization of his service. So his service was regularized. His services were regularized on 13/3/2002 and was posted as pump operator in the pay scale of so-and-so in the regular establishment. He superannuated on 31/1/2007. Then he filed a writ petition in the High Court on 31/7/2008 to count periods spent in the workers establishment as qualifying service under the rules of 1965. The High Court directed to submit a representation. That's why I'm not even reading this portion now. So the issue was there whether the part he spent as a workers employee is to be counted for the purpose of qualifying service of not to be entitled to get pension. So that was the issue there, Lordship. So this is not the issue in our writ petition, Lord.
Para 36.
Yes, Lord. So this para 36, Lordship, not connected with the issue in the petition before the Honorable Supreme Court.
Therefore, an obitter.
Yes, Lord. I'm not saying that. The court has said that. I'll place the judgment, Lord. Paragraph, now Lordship comes to page paragraph 36. There are some of the employees who have not been regularized in spite of having rendered 30, 40 or more years, whereas they have been superannuated, as they have worked in workers establishment, not against any particular project. Their services ought to have been regularized under the government instruction. Where is the instruction here? Where is the policy? And even as per the decision of the court of the state of Karnataka versus Umadevi, Umadevi laid down 3 conditions. Do they fulfill those 3 conditions? So 2 aspects your Lordship will take note of. First,
yes,
there is no such instruction or policy framed by the state of Assam for regularization of the service of the petitioners. And 2, they do not fulfill the conditions of Umadevi, paragraph 53 of Umadevi.
what were the instructions here indicate?
I don't know, Lord.
Must be referred somewhere.
So what the Supreme Court has said, one instruction was there. Supreme Court has also said 3 conditions of Umadevis are there. In spite of those 3 conditions, fulfilling of those 3 conditions, and in spite of having the instruction issued by the state government, if their services has not been regularized, their services has to be taken as deemed regularized. Now this deemed business, Lordship will come to this word deemed. This requires a statutory backing, Lordship. Where is that statutory backing, Lordship?
No. Sorry, you are referring to?
Same paragraph, Lordship, paragraph 36. If Lordship reads thereafter, Lord. This court in the said decision, Umadevi, has laid down that in case services have been rendered for more than 10 years, that is the second condition, without the cover of the court's order, no interim order, as one-time measure, Lordship, here the Supreme Court missed the main condition, that working against a substantive post. That was the most important condition in Umadevi. The services regularized of the such employees In the facts of the case, those employees who have worked for 10 years or more should have been regularized. Don't know, Lordship, for what reason court missed the most important condition of working against a substantive court. It would not be proper to regulate them for consideration of regularization as others have been regularized. We direct that their services be treated as a regular one. However, it is made clear that they shall not be entitled to, this is not important. So that was so one instruction, government instruction was there, and it was the view of the Supreme Court, Lordship, rightly or wrongly, I'm not going to that extent, that they fulfill the conditions of Kumali. But Lordship, as I have mentioned very earlier, Lordship, subsequent to 31/3/1993, state government never framed any policy for regularization of pastoral and workers' employees. In 2012, we issued the notification, which was initially set aside by the High Learned Single Judge, which was thereafter upheld by the division bench. Now, so far as Prem Singh is concerned, Lordship, I am facing another judgment of the Supreme Court. Uday Pratap. This is another judgment of the Supreme Court, Lordship, which deals with the Prem Singh judgment, Lordship. I am at paragraph 6.3. Yes. Now, insofar as the reliance placed upon the decision of this court in the case of Prem Singh by the learned counsel appearing on behalf of the appellants is concerned, the reliance placed upon the said decision is absolutely misplaced. In the said case, this court was considering the validity of Rule 38 of the UP Retirement Benefit Rules 1961, under which the entire service rendered as work search was not to be counted for qualifying service for pension. To that, this court has observed and held that after rendering service as work search for number of years in the government establishment department, denying them the pension on the ground that they have not completed the qualifying service for pension would be unjust, arbitrary, and illegal. Therefore, this court has observed and held that their services rendered as work search shall be considered counted for qualifying service. This court has not observed and held that the entire service rendered by the work search shall be considered counted for the quantum of pension. So this is one deviation from the judgment passed by our High Court in Pensionary. Next portion, Lordship. The decision of this court in the case of Prem Singh, therefore, would be restricted to counting of service rendered as work search for qualifying for pension. No other purpose. So this is the decision considering passed by the Honorable Supreme Court, considering the judgment of Prem Singh, Lordship. And so far as our High Court is concerned, Lordship, one judgment was passed in the month of August 2024, Lordship. I am only one paragraph. I am. Paragraph 14.
Para?
14.
14.
Yes.
Title, please.
Cited WPC number 1177/2007.
WPC.
1177/2017.
Yes.
Cited August 22/8/2024. Paragraph 14, my lord. The Honorable Supreme Court in the case of State of Nagaland Supra has also interfered with the action for effecting one-day regularization. As observed above, The direction made in the case of Prem Singh has been held to be confined to the fact of the case as observed by the Honorable Supreme Court in the subsequent decision of Uday Pratap Thakur.
What was the context? In what context?
Same workers employee lordship, they were claiming pension after retirement, court held, you are, as your services were not regularized, you are not entitled. Gita Burman versus State of Tamil Nadu. Same situation, same factor. Lordship, today's submission, Lordship, I made, Lordship, whatever judgments was available with me, Lordship. So Lordship will grant me some more time, Lordship, on a next day, Lordship, so that I can place my other judgment.
Yeah.
But in this case,
So are you saying that the same issue is decided in the
Gita
coordinate
Burman.
bench? Same issue.
And all, most of the judgment has been referred in this case. Specifically, Prem Singh.
Double 176. Five, five. Single bench.
Either tomorrow or 30th.
Thirtieth was 30th later. Take it right. 24, no, 30th, 20. 30th April.
Yes. All right. Counsels have been heard. The counsel for the petitioner has read his argument, reserving his right for a reply. His argument or everything. Matter listed again and have it on 13 May.
30 lot.
13 May.
Possible in this month. It will not take much time. 15, 20.
No, because there are other matters already fixed. We can try on 8th of May. 8th of
Lots of is keeping this as part.
Based on 8th of May for further hearing.
Right.
There are two matters. Huh?
Mr. Kienshore is leading the case and he's on his next manner. Maybe make a matter be fixed at 2:30. Made a matter be fixed at 2:30. He's on his next month.
2:30.
No, he's on his next month.
What is the problem at 2 o'clock? Huh?
He has some matter in at 2.
So you adjourn it. We'll take it up next week.
No, my lord, that my lord may fix at 2:30.
No, not at 2:30.
And my lord,
Either we call up at 2 p.m. or we call it up before the end of the list. We'll pass it over. You come and mention it. We'll pass over the matter. We'll call it up in the second half.
Okay.
Yes?
I think 31, Lordship, with the due permission of the petitioner, Lordship, and pass over the matter for the day.
Item?
31, last item of this day.
We are not even there. This is item number 11. Mentioning time is at 10:30 in the morning.
I apologize.
No apology, but it may reach, may not reach. If it reaches, we'll see what orders we'll pass. Yes. Yep. Yes.
My lord, to para 3, to 4, at 67th of affidavit in opposition. Para 4. That with regard to the statements made in paragraph 2 of the writ petition, the deponent states that the petitioner, namely Sri Mohendranath Pulita, has engaged in contractual term under PIF scheme in Assam Police Border Organization on 2010-1993 as SI ex-servicemen and retired from service on 30/4/2013 after completion of 19 years, 6 months, 12 days of service. Sri Ghanshyam Das has engaged in contractual term under PIF scheme in Assam Police Border Organizations on 192 as SI ex-servicemen and retired from service on 28/1/2011 after completion of 19 years, 2 months.
They have rendered service and then opted for voluntary retirement.
No, on superannuation, right? Only they are getting
superannuation. Then
only they have the getting the pensionary benefit, but from the date of only 1/9/2013 to 15, only two years.
Why?
You don't know, my lord. It's not known, my
Lordship, as per this OM that has been annexed with the affidavit in opposition at Annexure 1, Annexure A, Lordship, this office memorandum states about proportionate pension to the ex-servicemen who have rendered service in Assam Police Border Organization under preventive of infiltration of foreigners PIF scheme, Lordship. The petitioners have been appointed under the PIF scheme, Lordship. Pursuant to the cabinet decision held on meeting so and so, the government of Assam is pleased to allow proportionate pension and other admissible pensionary benefits to the ex-servicemen who had retired from Assam Police Border Organization under prevention of infiltration of foreigners PIF scheme, rendering more than 10 years but less than 20 years of service from the date of the initial appointment under the said scheme in relaxation of rule 31 of Assam Services Pension Rules 1969 in operation of Rule 235 of the said rules as a special case not to be
Alright,
treated
alright.
as precedent.
We'll come back at 2.
Lordship, all the three petitioners were engaged in contractual term under the PIR scheme in Assam Police Border Organization on 93, then in 92, and then in 93. And all of them have retired in the years 2013, 2011, and 2011.
On superannuation.
On superannuation. Lordship, the petitioners here are not eligible for pensionary benefits from the date of their initial joining, as per the government OM dated 21/1/2019, which is at Annexure A, Lordship, of our affidavit in opposition. It is clearly mentioned that pensionary benefits of ex-servicemen shall be effective only with effect from 1/9/2015, which they are getting regularly, Lordship. And that therefore their pension has been paid with effect from that date, 1/9/2015. In 30 April 2013, 28 January 2011, all before 2015. And at paragraph 5, with regard to their timescale increment, their cases have already been processed, Lordship. That is at Annexure B of our affidavit in opposition. Reference to the subject cited above, I am directed to submit herewith the proposal as per pro forma, both hard and soft copy for financial accreditation under MACP in respect of grade 2, grade 3, and grade 4 employees, including ex-servicemen of Assam Police Border Organization Headquarters, Guwahati, who have completed 10, 20, 30 years of service without getting regular promotion. And
Yes, ma'am.
yes.
My lord, already it is considered, my lord.
Huh?
Your lordship may kindly see Assam Services Division of Pay Rules 2017, my lord. It is already recommended, my lord.
It is already?
Already recommended, my lord, as per ROP 2017 rule, my lord. At page 732 or 372, page number suppose leave encashment and gratuity paras 1.6. The committee agrees with the recommendations of the commission. 373 page number. Medical allowance also recommended, and the commutation also recommended because they are retired on superannuation shown against their date of superannuation.
You are reading from that book.
Yes, sir. Yes, my lord. Petition number 2 and petition number 2.
तेरा क्या बचे थे आरोपी क्या पता था
Yes, my lord. Yes, sir. Frequently recommended for 70 commission. Accordingly, they are entitled for getting the 7-pay commission benefit. They are not getting their benefit, enhancements of pay, etc.
No, that is enhancement you'll get. What we are trying to understand is your prayer is for getting from the date of
Initial one.
initial joining.
Yes, my lord.
That you'll have to. That is as per the office memorandum, 21 January. Do you have the affidavit? Affidavit annexure A.
My lord, your lordship,
Affidavit annexure A, 21 January.
Proportional pension to be ex-servicemen who have retired. And the
Yes, you
service
see that pension benefit will be effective from 1/9/2015. Second last line. Third last line.
Yes. Only in case of pensionary, because the pension is fixed at the last pay thrown, my lord. So there is no question to the objection, my lord, because as per the last thrown pay, the pension is fixed, my lord. But other beneficiaries, suppose
You are not aggrieved by the fact that pension is not released from the date of your superannuation.
yes, oh yes, my lord. From the date of it was to be issued. Your listen, page number 13, my lord, in my read petition, my lord. Serial number 11, item number 11, my lord. Provisional pension, family pension nil per month plus relief medical allowance with effect from 1/5/93 to be to the date of last payment is to be adjusted, my lord. Already mentioned here.
No, now what is your grievance?
My grievance is, my lord, they are entitled for getting other beneficiaries, pensionary benefits, leave encashment, gratuity, and committee is not record, my lord. DCRC and other beneficiary medical allowances if they are not getting their medical allowances, etc. And also MACP with effect from 1/16 to till that they are not getting any benefit, my lord. So as per 7-pay commission, they are entitled those pensioners who are entitled for getting the pensionary benefits as per 2017 rule ROP. They are getting entitled for getting all pension benefits. Suppose amounts of retirement gratuity, DCRC admissible.
You never approach the authorities asking for those increments, whatever is entitled.
Already I approached, my lord.
Where, by which representation? Where?
My application is there, my lord.
Where is that page number?
Actually, in case of as per the Madras High Court rule, the other as per Supreme Court rule and judgment, individual case is not necessary.
You must raise a claim somewhere.
Yes, my lord.
They have raised out of the 3 of them, some they do not have any record, and one named Kumud Ranjan Rajbongshi, he had one application, but it was not visible, your lordship, hence we have not attached it to the petition.
Are they entitled to any other claims?
Lordship, only as per this OM, they will be entitled for this pensionary benefit from 2015, Lordship.
Onwards,
So,
till then.
onwards, till
No,
then.
no. They are now not agree with. They don't want pension prior to 2015. They say that there are other
Allowance.
entitlements. This your OM is not clear. Your affidavit doesn't say anything.
Please develop a that your workers may be pleased to admit to release their benefit, pensionary benefits which areas from the date of their due initial joining in time. Nalagay. That up to the date of last payment of their pensionary already with effect from 1/9/2015 onwards on regular basis as per to in the PPO at para 11. Right.
Your pleadings in the writ petition are you are claiming benefits from the date of your initial joining.
Yes, sir.
Then why are you saying that this is not your prayer?
Already as per my petition, there is a prayer for myself claiming.
That is the only prayer you are making. DCRG leave encashment has also not been paid.
Yes, sir.
All right.
That may be the release to the pensioners as per.
You get instructions, madam, about their claim in paragraph number 2. Para 2 of the writ petition. Their DCRG leave encashment, commutation, etc., etc. Whether they are entitled.
Commutation is not required, my lord, because the commutation is on.
What is not required?
Commutation is not required. They are not claiming for commutation. Only gratuity and leave.
Are they entitled or not to get it? When can you get it?
So matter will be disposed of with the on merit, my lord.
First, you have to tell us that you are entitled to us.
Yes, my lord. We are entitled for getting the pensionary benefit. As per
show us from what? You show us something, some material, some rule, some judgment that you are entitled to it.
As per ROP 2017, my lord, it is entitled.
Show us your book. You pass on that book. Let us see.
Okay.
You are referring to what?
My lord, pension related to superannuation in retiring as per leave encashment.
No. From here, how are you claiming the benefit? You have to show us. How does this
Already
entitle
they
you
have-
for the benefit?
Because in Civil Pay Commission, they have already recommended to it.
Where?
This point are point by point.
Point?
Leave encashment from 1 to Roman 1 to 10.
What is the recommendation of the committee? What is the recommendation of the committee? Right, heard learned counsel for the parties. This writ petition is filed by the petitioner, praying for release of pensionary benefits with arrears from the date of their initial joining in the services to be paid up to the date of their last payments of their pension on regular basis, along with interest and other promotional increments and benefits under the provisions of ACP/MACP. Petitioners, the three petitioners are ex-servicemen, and after taking voluntary retirement, they were appointed as what?
At the police border police payload under the directorate of the KIFS. The prevention of infiltration and
They were appointed under
KIFS. Foreigners. That is the prevention of infiltration of foreigners.
PIF
PIF
rules.
Yes, ma'am.
Prevention of infiltration of foreigners.
They are appointed.
Subsequently, they superannuated on various dates. They stopped. They rendered more than 10 years of service as under the pursuant to their appointment in PIF, and therefore they claim to be eligible for time scale increment under provisions of MACP/ACP, etc. The respondents have contested the case by filing their affidavit. The respondents contend that the respondent dispute the contention of the petitioner that they are entitled for payment of pension with effect from their respective date of superannuation. According to the respondents, as per the office memorandum dated 21st of January 2019, the benefits, pensionary benefits be available effective from 1/9/2015 as have been decided by the government. Stop. In pursuance to the said OM, petitioners have been granted their pensionary benefits. However, there is no averment in the affidavit filed as to the claims in respect of the claims made by the petitioners for other benefits like the CRG, leave encashment, etc. So, the respondent, the averment, there is an averment in the affidavit that the that their benefits under the MSCPS is under consideration and has been placed before the screening committee. Stop. Once the screening committee approves the claim, the pending MSCP dues will be disbursed to the petition. Counsels have been heard. Counsel have been heard for the parties. Pleading on record have been perused. Although the petitioner in their writ petition initially prayed for issuance of a direction to the respondents for releasing the pension with effect from the date of their initial joining in service. With effect from the date, by counting their services with effect from the date
only for because
of their initial joining in service. So, however, during the course of the argument, counsel for the petitioner submits that they have no grievance with regard to the date from which the pension has been granted, i.e.,
it is the last date drawn at the time of retirement.
1/9/2015 in terms of the OM dated 21st of January 2019. Counsel for the, however, the grievance of the petitioner raised is that the pension is calculated on the last drawn pay. And if there are increments which were required to be added, increments which have not been granted to the petitioner, the calculation of the pension on the last drawn pay is affected and they suffer a financial loss. So, the petitioner has not been able to place before the court any specific representations made before the authorities concerned with regard to their claims. Stop. On the other end, from the affidavit file, it is seen that their claims for grant of MSCP S is under consideration and subject to approval from the screening committee, the same will be dispersed. So, under such circumstances, since the petitioner's claim DCRG, leave encashment, etc., and other enhancement increments in their pay. And since there is no averment made in the affidavit of the respondent number 6 to that effect, we permit the respondent petitioners to file a detailed representation before the respondent number 6. The representation should clearly spell out the claims made by the petitioners. Stop upon filing the said representation, the authorities will pass a speaking order thereon within a period of 60 days from the date of receipt of such representation, along with a certified copy of the order passed to me. So, the filing of the representation and the consideration of the state representation, if filed, shall not be a ground to consider payment of the MSCPS, which MSCPS, if the petitioners are otherwise found to be entitled to by the screening committee. With the above observation, the petition stands disposed closed. No order is proposed. Yes.
My Lord, there are subsequent developments in this case, my Lord. So we have filed writ petitions which are coming up tomorrow. May I pray, my Lord, these two matters may also come up tomorrow.
Otherwise, my lord, the claim for regularization, my lord, a particular
Let me
scheme
complete.
that has been rejected.
No.
So it will come tomorrow along.
Yes. So, my Lord, actually what had happened, now they have rejected on the same very ground which was interfered with by your Lordship. Anyway, my Lord, Lordship can apply the mine tomorrow, my Lord.
What is the claim here?
Here, my Lord, what had happened, there a transfer exercise was carried out, where, my Lord, we didn't have a post. There were relievers for us, but we had no post. So court has protected us.
In this matter?
Yes. So I'll only pray, my Lord, today's this interim order which is operating shall continue till tomorrow when Lordship will take up the.
What are you challenging tomorrow?
Now tomorrow what I'm challenging, my Lord, there was a judgment by your Lordships, whereby your Lordships interfered with the earlier order of the government, whereby our claim for regularization was rejected. And Lordship directed that government should revisit. Now, on the same very two grounds on which earlier it was rejected and which was interfered by our Lordship, on the same very ground.
Separate issues.
Otherwise, separate.
No, otherwise separate, but it has got connection, my Lord. Supposing tomorrow Lordship holds that my claim for reservation, regularization is to be upheld, then, my Lord, this will have relevance. That's why I'm saying let it come tomorrow, my Lord.
No. It can come tomorrow. What we are saying is.
And in fact, it has already been listed item 15 and 17.
No, that's all right. What we are saying is that the issues are different.
Issues are different, but intrinsically measure connected with each other.
That's right.
That your Lordship will take a call tomorrow.
All right, but we will prima facie from whatever you submit, these issues are different. It can always be connected later. Tomorrow is a fresh matter. These matters will be deferred at some other date if you want to hear it.
Difficulty because from November 2023.
There is an interim order.
Yes, there is.
Let me specify. From November 2023, their services have not been extended by the government. That's the whole issue, my lord. That fact we have placed in our affidavit. There is no extension after November 23.
At the same time, there is a direction of this honorable court to take a decision on my regularization, which is prior to that.
That's a separate issue.
All right, let it, then we'll put it on Tuesday, these matters. Let it come on 29.
29.
29.
An interim order.
Interim orders, if any, will continue till
Till
the next
then,
day.
We will consider the entire matter on that day because
29th.
Yes. Today, because my lord, their my lord, prayer for regulation has been rejected and they are not in our service, my lord, at all, except the interim order which is particular. Otherwise, they are not there on record.
29th. List
Please
these
hold
matters
on.
on 29th. Interim order passed earlier, will continue.
Hello, could it be inconvenient on 30, Miller?
30 is
Oh, Wednesday.
miscellaneous day.
Okay, let it be 29.
Or we can have it on first.
No, let it be, Milord, 29. An interim to continue.
Yes.
Till then. Deep.
May it please a lot. It's a charge sheeted case, my lord. We are behind the bars, my lord, but your lordship had passed an order, my lord, granting us interim bail, madam.
Lordship, as per the status report dated 17/12/24, further evidence was on 26/12/24. So, Lordship, recent approval status is required. Lordship.
But what happened, my lord, in this case, my lord, there are two persons, my lord, two accused, my lord. One Safiqul Haq and the present petitioner is Nurchan Ali, my lord. My lord, that Safiqul Haq, my lord, he has been granted, my lord, absolute bail, my lord, by a coordinate bench. But in that case, my lord, your lordship order has been reflected.
He was on interim bail earlier.
He was not on interim bail. Passing lordship, after passing your lordship order, this order was. We were granted interim bail on 25/11/20.
All right, let us call for, it says up-to-date status report is necessary.
My lord, one more submission, my lord. If your lordship goes to the LCR, man, for a once. Constitution. LCR, my lord. One flag mark, my lord, I have noticed, my lordship has seen, my lord.
Yes.
Notice, my lord. But this is a note that was a notice, my lord. Well, why I am referring to this notice, my lord? The lordship will see, my lord, first. The Constitution of India for a month.
Huh?
The Constitution.
Constitution.
Constitution. Yeah, 47.
Yes, constitution which.
Yes, my lord. 22-1, my lord. 22-1, my lord. My lord, no person who is arrested shall be detained in custody without being informed as soon as may be of the grounds of such arrest, nor shall be he denied the right to consult and to be defended by a legal practitioner of his choice. Got it, lordship? CRPC.
Yes.
Now, your lordship have to go to the my lord, CRPC, my lord, for a month. Section 50 and 50A, my lord.
You are talking about the grounds of arrest.
Yes, my lord. That has not been provided, my lord. So, the recent judgment of the Supreme Court, as well as, my lord, There's some
I think the latest judgment, I think is.
Vihan
judgment
Kumar.
is reserved.
Vihan Kumar.
Judgment is reserved.
No,
Subsequent.
subsequently it was
Judgment is
subsequently it was referred to the larger bench.
Decide whether on every case it is required.
Yes, every case it is required or not.
So we decide on that.
Yes, my lord. That's
Well,
one
let us
point.
call for the appropriate status.
My lord, otherwise the other co-accused has also protected. My lord. Leave it to your lord.
Let up-to-date status report be called for by the trial court as it is submitted by the APP that.
And that's
And thus that when was the last?
as per
Date?
the status report, last date of evidence is 26/12/24.
As the last date of evidence was 26/12.
Yes.
No date has been fixed now. Why? And also all subsequent dates on which the matter may have been listed. Is the matter after 4 weeks? Interim order passed early will continue.
My lord, I'm obliged.
Okay, sir.
Except item number 16, my lord. In other two cases, I have no instruction to appear, my lord. 16 and 9.
What are these matters?
Perhaps these are promotion of the petitioner. In fact, in my presence, once he mentioned deportation about court matter in different court. Court earlier did not allow them to take all this matter, but somehow subsequently when the
It's similar matter.
promotion matter, how the referendum proceeding will be connected with this.
Lordship, my senior is on legs in another court, but our part was over on the last occasion. Respondents may do their part and leave noted.
You want to argue today?
My God.
You are arguing today, replying today?
Your lordship,
No, it's up to you. I'm asking you.
yes, madam, I can do. So only in respect to two items, madam. I'm appealing, madam.
Item number 16 and
19, I think. Two matters are similar. First, before passing the impugn dismissal order, first case was 5 matter. Then after.
what happened here? There was a show cause notice.
Yes.
PP was started.
Yes.
In
The
inquiry.
crux of the matter is, madam, whether in the present facts and circumstances, de novo inquiry can be initiated or not. That is the crux of the matter.
Yeah.
My respectful submission before lordship, madam. In the present facts and circumstances, the de novo inquiry can be initiated.
So give us the gist of the.
Yes. I'll reply to that. My lord, had it been a case that the finding is in favor of the petitioner.
No, give us the gist of the case. Why de novo inquiry was necessary? Why was it initiated?
Lordship, gist of the case, my lord. That, my lord, I have not. In that case, my lord, next Tuesday or Thursday, my lord, I'll do that.
You are aggrieved not only by the de novo but by issuance of show cause by the inquiry officer.
Yes.
Subsequent inquiry.
All the settled provisions which are there in the disciplinary appeal rule, not most of the provisions flouted in conducting the.
You want to do it on some other day?
Yes. If this is required to be submitted, then my lord, Tuesday or Tuesday will not be, but Thursday.
Gist, we don't want you to submit the gist. We were asking you, give us a gist of what happened and what was the ground of argument. So if you need something to prepare, we can have it on 13th May.
My lord, 13th. Okay.
We'll try to complete the matter on that day.
Yes.
13 May. All right.
So far, I am concerned, my lord, on the last occasion I completed my
Yes,
part.
we have your note.
Yes, my lord. Even then, my lord, if your lordship requires any assistance, my lord, I am there.
Yes.
I'll assist your lordship in coming to conclusion after the submission of my senior friend.
We are keeping it on 13th May.
Fine, ma'am. Fine.
It's on 13th May at the request made by Learned Edition of 18. P. Goswami, representing the respondent. Mr. H. Das, counsel for the petitioner, has already completed his argument.
May I please, Lordship? Lordship, I am praying on behalf of Mr. Counsel A.K. Protest.
Let it be together. We'll pass orders on that day. No, now it is already connected. So we don't want to segregate it today. We'll do it on the next day if required. Yes.
Lordship, he is on leave, Lordship. Mr. Counsel A.K. Protest.
He is on leave.
Yes, Lordship.
For how long? When is he likely to be back?
Today, Lordship.
Huh?
Only today, Lordship.
Only today.
Because he is not well, Lordship.
You are his junior.
Yes,
All right. You read the file. We'll take it up on Tuesday.
Lordship.
You read it. You prepare the case.
Okay, Lordship.
You take the file, read it. We'll take it up on Tuesday.
Okay.
What is your name?
Bong Pirong Hangki. Birong Hangki, Lordship.
We'll record your name and we'll call up the matter again on Tuesday. List again on Tuesday.
Okay.
Tuesday की तारीख होगा 29. 29. MSM Bhattacharya is for the list on so and so at the request of counsel.
Lordship, I kindly pass over this matter for time being. My senior is on leave on port number 14.
You argue hearing matter. You argue. On 1st of May. 1st of May at the request of counsel for the
Right, please. My lord, matter pertains to my lord parity of penalty. Actually, out of the same incident, lordship already heard the matter. Out of the same incident, my lord, 8 persons were involved, and all the 7 persons were treated differently, and only in part of my side, my lord, I was removed from service. Whereas the other persons were either reinstated in service or some 3 persons were given the punishment of compulsory return. The last occasion, my lordship directed the respondent authority to produce the relevant record that out of the same action, my lord, whether DP matter.
When it is a question of parity with other persons, lordship, those persons are not the party in this. Because it has to be a question of the necessary means under necessary.
How?
Because he is comparing his case with other.
He is not claiming relief against this person.
He is comparing his case, lordship, because the separate decree has been filed against this.
Those persons belong to the same department or different department.
Same matter.
Other persons belong to same department or different department.
Same department, has to be same department.
So who represents the same department? You are there. The same department. The grievances against the department, not against this person.
We have to consider the evidences and
look into the record. Therefore, the record.
That's what lordship. This is the record of only against DP2 of 2014. DP2 of 2014, it is
initiated against who?
Against lordship this Vijit Kumar Day.
Petitioner.
Yes.
So you are to compare the.
Those the records of those DPs has to be lordship call for lordship.
Call for it is in your custody. It is not in the custody of those persons.
I am not disputing it. I admit, lordship, that is in my custody. The thing is that, lordship, if I have to, lordship, establish my case on the basis of lordship inquiry in regard to the DP of Vijit Kumar, then this records will be sufficient. Then if I have to compare, lordship, then I have to get the records of other persons.
Yet, who is stopping you? We are not restraining you. He is saying that there is one show cause.
Yes.
Against all.
Yes.
Where is
the same code? What of the same inquiry, madam?
So I have to see, lordship, the evaluation of evidence, whether that is same or not in all the cases.
Where is the show cause?
Show cause, my lord. It is page 31 of the report.
31.
Yes. Is against me. First show cause.
What about the other show causes? Against the other person? You don't have?
No. That's why my lord record was.
Then how do you say that the allegations were one and the same? On what basis?
If lordship may kindly come.
Where is the inquiry report?
Inquiry report is there, my lord. At page 41, lord. Starts from page 41.
So to draw up, to build up a case of parity, you have to refer to the allegations against the other person. Merely because you are dismissed, others are not dismissed, is not a ground for parity.
No, my lord. If lordship may kindly come to my lord inquiry report, everyone's statement and record.
Is the inquiry a common inquiry for all?
Common inquiry. If lordship may kindly look into my lord, that is page 43 onwards, my lord.
Where?
প্রদীপ কলিতা, শঙ্কর দেব সূত্রধর, অশোক কুমার বরা, গোপাল চন্দ্র
You seem to be preparing your case now. He is supposed to be hearing you.
my lord.
If you are not ready, you prepare and
Then my lord, lordship may twist down.
not
You
use
can
the.
have me the names also. I can find out the actual DP number and the records also. I'll try to get. নাম কেটে দিলে হবে।
Why are you asking him? If these are your
because he is comparing his case to two three persons with whom he is comparing.
right 13th May, at the request made, joint request made by the counsel for the petitioner.
I might suggest also he may tomorrow say that no, I am not comparing his case with this one. I am comparing his case with that. But that is the provide me the name.
Whatever is available in your record, you get it. Regarding this incident, how many persons have been proceeded with?
In my record, there are two names, but I don't think also his grievance against those Gopal Das and another one.
No, not
Yes,
His
but in the record,
his grievance is not against anybody. His grievance is against the department on the ground that for the same incident, you have given punishment. There is a difference in the punishment.
That he has to point out, Lordship. That he has to point out.
No, that is very much clear from my affidavit in reply, my lord.
Yes.
140.
You show us on 13th. Yes.
Affidavit in position of case 141. नाम भी था कभी।
Deputy Officer of Cultures.
Yes.
Lordship, I'm pass over the method for a day, Lordship. Next week, anything.
Why?
Sterling until that they can also he just left the court.
He has left the court. Why has he left the court?
Some attention, some personal. Next week, Lordship, anything.
Yes, Mr. Soikia.
His singer also told me, but I am ready to do the guest. And since they have requested, let it be, my lord, on Monday fixed,
Not on Monday.
my lord, or Tuesday. Case is very simple. For a single offense, my lord, if we accept that the offense, punishment was given. And again, second punishment, the next managing director want to impose another punishment.
All cases are simple.
Punishment, my lord, they asked me to pay the rupees 5 lakh. The petitioner paid.
We will keep it on 8th of May.
Next week, my lord.
8th of May. 8th of May. Matter be listed again on 8th of May at the request made on behalf of Mr. J.K. Goswami, counsel appearing for the
Sterling Apex Bank.
Apex Bank, Cooperative Apex Bank.
Assam Cooperative
Assam
Apex
Cooperative Apex Bank. Mr. R.C. Soikia, Learned Senior Counsel, assisted by MS.
By K. Soikia.
K. Soikia appears for the petition. List on 8th of May.
Senior Advocate KM Chaudhary sir is leading the case, Manoj. He's still on his legs, Manoj. Maybe fix on the next week, Manoj.
Yes, Mr. Chaudhary. Second week of May.
If it is possible, first week, Manoj.
Second week of May, when? 13. All right. 13th.